I think the more the sunlight, the better for all of us. He's somebody who's a personality, who has the whole yoga world, and I would say national, internationally was known. So obviously there was curiosity. Can't blame people for being curious. But I always do think that isolation shouldn't be meaning that you live in an ivory tower. Your hand should be on the pulse of the society. In today's day and time, as judges, one can't be cut out from reality. That would not be good for the system. One should know how the public is dealing with issues, what are the difficulties they are facing, and how best can we ameliorate them.
Hello everyone. We have with us Justice Hima Kohli, a former judge of the Supreme Court. She retired from the Supreme Court just about a few weeks ago. Has it been a month?
Not just about, going to be, 1st of September.
Just enough time for her to start picking up a newspaper every morning again.
Yes, that's right.
Justice Hima Kohli has been a judge of the Delhi High Court. In fact, she's somewhat of a lucky mascot for all her seniors she worked with, because each one of them went on to become a judge, and one even a Chief Justice of India. She practiced for a couple of decades before she became a judge of the Delhi High Court. She was also the Chief Justice of Telangana High Court before she came to the Supreme Court. Welcome to the
Thank you, Apurva.
I wanted to begin by asking you something I noticed at your farewell, which was, I think, so telling of a lot of things in the Supreme Court. On the last day of a judge's tenure, there's something called the ceremonial bench. Where the outgoing judge sits with the Chief Justice of India, and members of the bar sort of come and acknowledge that, and so everybody who was talking to you that day were really finding it difficult to pick the right adjectives. They said you're very soft but also very hard, very tough but also very kind. I think it was just balancing, because there's so few women judges in the Supreme Court, and I think the bar was also genuinely trying to find the right adjectives. And when you came into the court, and that was a milestone moment, because we had three women judges at the same time.
Quite.
Have you, in your tenure, did this register to you that your gender plays a role in what you do in court, or how it's so important to what you do in court?
Well, ordinarily, and I'd say ordinarily because when I came onto the bench in Delhi, we had some women who were already there, and most of them were from the district judiciary except one. And then others also came in, so one had a comfort zone. It was not as if you were a standalone, or you were just, a minor. We were a minority even then. Maybe we were in a court of 36 or 38, would be just about 7 or 8 women, which was quite a bit compared to other state high courts. But when you come to the Supreme Court, and we all know that looking at the numbers and the years, I was the 9th judge to be appointed, woman judge to be appointed in the Supreme Court. And we are talking of a span of 7 decades. So that says much about the fact that we three were considered a novelty of sorts. Because there was always one off. If there was one woman on the bench in the Supreme Court, probably she would retire and there'd be a gap before even the second one came on. It was not too often that there were 2 women at the same time on the bench. And here, when me and my 2 colleagues, Justice Nagaratna and Justice Bela Trivedi, joined in, Justice Indira Banerjee was there and happily welcoming us. So it felt good to be at least 4, if not half a dozen. I only hope that I live to see the day where we have a buzzing court of a Supreme Court of maybe 50% women representing the population in proportion to the women population of 48.5% in the country. But that will take a bit of time, let's be honest.
But how do you see that happening?
I see that happening now, and there are good omens. If there are good omens, then this is one. The number of women who are opting for the judiciary in the district courts is really huge now. Particular states have more than 50% women who are at this moment in the judiciary. Very many states. I can take examples of Delhi, I can tell you of Telangana, I can say Punjab, many of them. So as they go up in the ranks, there'll be a larger pool to select from. That's one. Because as you know, 1/3 of the judges who come in the High Court are from the District Court and 2/3 are by appointment. Those like us who are lawyers practicing and were invited to the bench. So that pool of 1/3 is expanding. We'll have more choices, more women coming up, and hopefully coming right up to the Supreme Court too, if they come in at the right time in the High Court, have enough time. Secondly, the number of women lawyers is also now much more than what it was earlier. Net, we never had so many senior women advocates as we do now. That shows they've made a mark in their career and they're doing well enough to come in that pool for consideration by the collegium for appointment to the bench. So as the pool expands, the number is bound to go up. It's going to be in direct proportion. When we came in, there were lesser number of women. So where was the choice? They didn't have so many choices. When even today, as I speak to you, I think today there are 2 Chief Justices in the country who are women. One of them demits office maybe this week or around the corner, and another one. So invariably you are left with 1 woman Chief Justice, and that is why probably the collegium has to go down and look at a puny judge who's a woman for appointment, because you don't have that many women Chief Justices or those who attain that position for being considered. So it's interconnected.
This is, of course, one institutional area that the court really has to work. It's not just about what your pool is, but how you pick and the processes as well.
True.
And when it comes to appointment, it's also one area where you see a nudge from the government once in a while. So have you seen, how do you see, it's been 30 years since we've had the collegium system. How has it moved the needle? Because when it comes to representation, there's still definitely a lag. But also, how the collegium's functioning itself, how do you evaluate that?
See, as a judge, puny judge, number 1 or number 2 of the High Court, you are part of the collegium when you get to select judges or invite them to the bench. I was the Chief Justice, so I was part of that collegium too, as I had to make recommendations, which I'm glad to share. We almost recommended 20 odd judges during my tenure, out of which most of them made it and are now at the moment sitting judges of Telangana. The Supreme Court works each court works differently. Supreme Court has to look at pan-India, whereas in the State High Court you are looking at basically the judges, the lawyers within that court. Incidentally, even when you look at it within the court, normally the focus is those practicing in the High Court. It is important, I feel, to also pick up candidates from the district courts who are doing well, who should be part of the system, and their experience should also count. Just because they have not been seen in the High Court should not be a disadvantage for them. That is my feel, and I do feel that we should certainly pick up candidates who are good on merits from the district courts, whether criminal or civil. When it comes to the Supreme Court, it's a different criteria. They have to see what is the kind of informal criteria, should I say, what is the representation of a particular state in the Supreme Court, what is the representative of those in the minority community. Again, when they talk of women, it may be that the focus is that let's have at least, sometimes earlier it should be let's have at least 1 woman symbolically so to represent the entire women community of sorts in the Supreme Court. Earlier there were no reasons given. As you know, the collegium would just declare the names and wrap it up. Or sometimes reasons are given for appointing a particular candidate. One looks at the body of work the lawyer has done. That also counts. Many times one also looks at, not in the Supreme Court but the High Court, the jurisdictions. So for example, one finds in some states that there is nobody to represent the tax aspect. And taxation is a big thing, GST, income tax, direct, indirect. So they'll look specifically, one would look out for a taxation lawyer. Or the criminal side is not adequately represented, you need good criminal side lawyers. So you would go down to look and identify them. That also counts, because that kind of experience is good on the bench. But in the Supreme Court, the point is, in High Courts you have jurisdictions. And you work on those jurisdictions for a particular period of time. In the Supreme Court, everything is thrown at you. So whether you are doing tax or not, or whether you're doing arbitration or not, or whether you're doing land revenue, all of it will come your way. The assumption is that over the years you would have honed your skills. in the high courts, to be able to handle matters which you would be bound to handle in the Supreme Court.
But of course, the subject matter expertise is very crucial.
Yes.
But how important is it to have this sort of representation now when it comes to, say, caste or from the minority community? Also, we talked about gender as well, because all of this is contested, and there's the conversation is why should you have, why should you look at specific representation? Why should you always have a minority judge? These kind of. So, how important is it to have?
It gives a balance. It gets more people with their experiences onto the bench. It adds value. And what are hands-on experiences, all those layers which you carry with you, they do add to matters of the moment and matters which are constitutionally important. So I should think, and I'm not saying communities at all. It should not be done that way. In any case, merit should count, and if that is the only count, I would say that maybe then many would be sidelined and would not have a representation at all in the apex court, which would be to an extent would create an imbalance of sorts. So those life experiences they carry would count to mull over and interpret the Constitution in particular manners. It broadens the path.
I think one example that comes to my mind is, of course, the bench when you were sitting with Justice Nagaratna.
Right. Yes.
A couple of abortion cases that came before your bench.
That's right.
There was, of course, a lot of conversation around two women judges hearing these issues.
Yeah.
And especially because both of you disagreed on a few things.
Absolutely.
So, I want to ask you about that case also.
Sure.
This is a case where, the debate was essentially around the rights of the fetus itself and the right to the woman's right to choose. And in that you said, initially
we both agreed.
Abortion, and then you said your conscience would not permit you to continue with
Yes.
this. So I want to ask you what was going on. Have we changed how we look at this issue in jurisprudentially in India?
To start with, I didn't say my conscience. I said my judicial conscience.
Yeah.
So that makes a difference. I always prefer to keep myself as me away when I am on the bench, because we have to look at things judicially. This was a matter, and now I'm being specific to this matter. But let me give you a background. It's not the first time this kind of a matter comes your way. They come all the time in the high courts. Not all matters are straight filed in the Supreme Court. This one was, for some reasons. So we've handled it, and there are plenty of times that one has given the consent looking at the circumstances of the person who approaches us, the woman who approaches us, or the family that approaches us on behalf of maybe a juvenile or somebody who's got medical issues, and so on and so forth. So it's not the first time. The only thing perhaps that engaged the public and the media was the fact that this was a bench constituted of two women to look at it. We have done it as two women even in the high courts. Initially, what was placed before us by the council was the status of that lady to say she's reluctant. They have a complete family. And by the time they came to us, they had crossed that Rubicon of 24 weeks, which is the statute mandates that after that you have to be very careful to filter and see what is the criteria laid down. And if it fits that criteria, then only give your consent to the woman dropping the child or the abortion. Now, in the facts of the case that was before us, though the petition did say that she had issues because she had some psychological issues and others, so she was not mentally prepared to continue with the pregnancy, we had asked pointed questions on why did they wait that long. Those circumstances which she was speaking about were existing even earlier, in the earlier pregnancy. But it is almost done that we send it to a specialist body, which are doctors, and preferably a board of doctors that examines the patient before we make up our mind, because we must be supported with hard facts and medical background, which is the basis for coming to a conclusion. The way the report came, it was worded, to my mind, a bit guardedly. And that was as an afterthought. So when we looked at the report, it seemed to, we felt that maybe there was ground enough for that lady for us to give consent for the abortion. Matter stood there at that stage. Then came a second report, which was placed before us by the same set of experts. The second time, they were more candid. The second time, it appeared, and it was quite clear from the report that one, that the child, the fetus, had a life by then. Two, they didn't seem anything unhealthy about the fetus physically. And that they also informed us that the life of the woman would not be in danger. And the hospital this was AIMS, was willing to do all that to take care of. Looking at that, and then there was a lot of back and forth, because before we took a decision, we wanted to talk to the lady. We were doing it virtually because we didn't want to disturb. So her husband was physically in court, but it was not the husband we wanted to speak to. We wanted to speak to the lady. So we got her on board, and though there was interaction, one could see she was fairly confused. It goes with the territory. When women are pregnant, they go through lots of highs and lows. Nothing can be on an even keel. All of us know that. There are a lot of emotions involved and anxieties involved that a woman goes through. In that process and in the interaction and on going through the records, to my mind, it was a case where maybe the child, the fetus who had a life, took precedence over the mother's resistance to having the child. And that is why the second time when that application came with the second set of report of the AIMS doctors, who I had castigated for being too guarded in their earlier report, and had they come up with the same information, we may not have lost time and taken a different call. But because it appeared to be a little too guarded, we took a different call. So the second time I was clear that my judicial conscience did not permit it. And I was not agreeable to going ahead with a pregnancy being dropped. Whereas my sister felt otherwise, and that's also part of the record. These are matters of moment. You can't wait. You can't sit down and decide that you will write a whole thesis on what are the comparative rights of a woman, pregnant mother vis-a-vis the child, because every day and every hour is counting after 24 weeks. So therefore, it was a short order. Both of us dictated. And because there was a dissent, it went on to the Chief Justice who constituted another bench, which did happen. As an aside, which months after, we don't follow matters, but this is a case of a child, a baby that was being born. I did check, because at that time, the mother wasn't very keen to retain the baby even if it was born. And an assurance was given by the state that if the child is born and they don't want to keep that child, the state will take over the child and make sure that it has a home. So much later, I did ask around, and I was told that it was a body baby boy who the parents didn't want to part company with, and insisted that they wanted to keep the child as part of the family, and they had settled well. It was very heartening for me to know that. Not that would have counted when the decision was taken, but post-decision it felt good to know that the child remained in the same family and remained with the biological parents.
I also asked you this because, at the time when this case was being heard,
yes,
there was, of course, this parallel conversation in the US on the Dobbs verdict, and fetal heartbeat as a yardstick is not really a concept in India that we had recognized.
Yes.
Or that being the yardstick to allow abortion or not.
True.
Then after this verdict, there were a couple of cases which went that way in the Delhi High Court, also one more in the Supreme Court. So it did seem like that was a turning point in how India looks at abortion. So did you see it that way?
I think it is very case specific. There was no message that was being given that a woman can't drop a pregnancy in circumstances contemplated under the statute. And there are circumstances and circumstances. You know that cases of rape, cases of violation of the body. After all, ultimately we recognize the fact that the woman has a control over her body. She's the only one who can decide what she wants to do and how she wants to go about it. There are psychological issues, there are health issues, there are so many issues. When a child is deformed, the fetus is deformed, we do that also in the interest of both the mother and the child. All of that is a part of our jurisdiction. It is part of our judgments. one has to take one case at a time. And that it has to be case specific. You can't draw general analogies and say this case is like this and the other one should follow. Each case has its nuances. And how you decide then, much depends on that. So I wouldn't say that any such message was being given, that the right of the fetus overcomes the right of the mother, because ultimately she owns that the body in which the child is living. So it can't be that you will make small of it. One can't make small of it. I don't think so.
Of course, the other judgment where these questions of consent, dignity, all of this was writ large, was the same-sex marriage decision.
Yes.
I think when the bench was set up, when the case was being heard, everybody had a certain expectation of the bench, knowing all of you and your track record on these issues, right? All 5 of you had delivered judgments overwhelmingly in favor of liberty in your long tenures. So, what was going on in your mind when you were hearing the case? And
see, I'll be very candid. We were open to everything. And this case went on for a long, long time because the arguments were fairly convoluted, and there were several counsels who wanted to have their say, and each one was given a chance. So it took a lot of time. We were open, and I think it's very important to be open and consider what all parties have to say before you actually sit down and mull over it. And I think by then we were almost into the summer vacations, if I'm not mistaken, or around that time. I'm not sure. April, May or something like that. It was a copious hearing. And since you were there, you would know better. All views were taken into our mind. And then came the judgments. The judgments are, when we don't immediately sit down and start penning it. These are important matters where you want to sleep over. You want to consider, you want to go back to what people said, what were the nature of arguments, then you put it in a perspective. This is how a judge works around these judgments. I wouldn't say I'm the only one, all of us do that. When they're longer, and we don't necessarily discuss, not necessarily, in every case, if it's a constitutional bench, all 5 of us will put our heads together and have a discussion. It'll depend on which way you're going, and ultimately if drafts come out, when we have a sitting, we exchange views. If there is a difference of opinion, as in this case and there are in many others, sometimes those are nuances, legal nuances, which one can overcome with a discussion. You're open to being persuaded one way or the other. Other times it relates to the fundamental issue, on which one may take a different view, but then that's what we are all about. When we judge, we take views. We take different views depending on our thought process and our approach to the question before us on the statute, so on and so forth. So in this case, I leaned towards, I would say, what was authored by Justice Bhatt. And having read it, of course, which normally public doesn't know, is when a judgment comes from a majority, it is maybe authored by one judge, largely. But the contribution and the inputs from the others who are also party to it is always there. One may tell one's colleague, look, why don't you add this? I think this aspect needs to be handled. Maybe you can elaborate a particular aspect. That goes on. That is a churning from within. So you don't just sign the dotted line. You contribute in your way to whatever be the view of that particular judge with whom you're inclined to go. And that is how the judgment evolved. So in my mind, we were very clear that they are entitled to many rights. Several of them were put on the record, and we said that the respect that goes with this, one must respect the relationship, one must respect their independence, one must ensure that they have all those rights of opening bank accounts, of provident fund accounts, of having, joint accounts, all of that, transfers of properties, everything. But we were talking of the fundamental issue at that time was recognition of marriage under a particular statute. And I agreed with Justice Bhatt that statute was not tailored for this particular relationship. One could not read so much into it or read it down so much into the statute to be able to give it a sanctity in law.
It seems like there wasn't enough persuasion from whoever was pleading the case.
They persuaded. They did their best. I will not find fault with any counsel. They did their very best. But ultimately, it's your call, right? How you want to go. And that is why the majority went the way it did. As you know, in that case, Justice Bhatt and Justice Narasimha and I were decided to agree on a particular line. With Justice Narasimha having added his own separate little order, he did a short piece. But we felt like that, and we went like that.
But where do you see the marriage equality movement going from here?
Look, at the end of the day, these things should come from the society and go up. It can't be foisted by the judiciary and filtered down. That's not the route. If the society is more accepting, if the society evolves and grows as it does, and all of us are doing it from time to time, this may be a reality maybe in the near future.
But it was a Supreme Court who took it
Yes.
from the High Courts and heard the case.
Right.
Was that, perhaps if that wouldn't have happened,
Yes.
the legal journey would have been longer.
Perhaps.
There would have been more debate.
Perhaps.
But what do you make of that decision now? Should the court have, taken it up out of turn, heard it?
I can't comment on that because that was the prerogative of Honorable the Chief Justice of India to have taken it up. They were pending matters. It's not as if he pulled it out from various courts. Perhaps that was done earlier, prior to him. I don't have a recall. Whichever the Chief Justice was. To my mind, and I've said that often, when a petition is filed directly in the Supreme Court under Article 32, many times one would tell the petitioner that it is best that you approach the High Court being a constitutional court first, because that 226 works there too. And constitutional courts are competent to decide all that. And then come to us, because we must have the benefit of one judgment at least, or two judgments. Many issues are before several High Courts. So let them take a call and give us the benefit of their view, and then we do it. So there's a layer, right? Sometimes it works better to my mind. And when we have, even for example, taxation matters and such, where the government comes up and says, club them all, bring them to the Supreme Court, because we have got multiple cases pending before multiple High Courts. It can land up in contradictory orders. Sometimes you do say in those transfer petitions, all right, let us say out of 20 odd cases, a majority are before a particular state High Court, let that state High Court decide, the others stay their hands. We get that judgment. Or many times we say, all of you go to a state High Court. That also happens. And that matter will be argued before that particular state High Court, which is seized of it, which is at an advanced stage. Give your views, get a judgment out, then we take a call. Instead of everybody doing it separately. So there are ways and ways, and to my mind, having the benefit of one judgment coming from a constitutional court is certainly required in many matters.
But this was also a case where, the government had a very strong opposition to a judicial review of this. And you've seen that line of argument by the government in the last few years in many cases, where they would say this is the legislative domain and the courts should not be looking at it.
Right.
Whether it is sedition for that matter, during the stay also this same thing was argued, that it's not the court's domain to look at it. Of course, what we had even just till early this year was a majority government with a strong majority and saying that to a court, and in most cases I think the court also yielded to that and said, okay, we'll stay it for now, you come back and tell us what you will do legislatively. How do you see this play out in court every day? Because the government has very strong views on certain issues. And what is the extent of judicial review that's possible in such cases?
See, that also depends on what kind of legislation we are talking about, what kind of enactment there is. There are times when the government has given its view by virtue of a legislation, which is sometimes read down, sometimes struck off the book. There are times when even if it is struck off by a judgment of the Supreme Court, and it goes back, the government decides to come out with an amendment and which results in neutralizing that judgment, because that is the duty of it lies in the domain of the legislature, and the judiciary can't question it. Ultimately, they are representing the larger public. They've been an elected body, so it is their domain to do it. The only thing is then that is retested when it comes back to the court, Supreme Court, High Court, wherever. And on the whatever are the anvils of judicial review, we are looking at the larger picture. So it is, of course, there is resistance many times, whether it was the previous, you're saying the stronger government, or even prior to that, several governments. There is resistance to many of the views that the courts take, and many times the legislature dilutes that by doing things which they can get around that judgment, in a manner of speaking. Sometimes they succeed, sometimes they have to succumb. So it goes on. It's an ongoing process.
Like your Delhi judgment, for example.
Yes.
The Constitution
Right.
bench did
Did.
say that it tilts in the favor of the elected government, but when it comes to appointments, that's
True.
been neutralized.
True.
So,
And that's also pending.
but that's pending. But
Yes.
in the meantime, these things are, it's fait accompli. For a year and a half now, the situation has changed in Delhi. So, are there certain, say, no-go areas when it comes to judicial review? National security being one, or which is the usual sort of government's refrain that they keep talking about.
No, but see, every matter can't be taken up immediately. Now we are talking of constitution benches. When you talk of constitution benches, let us not forget that's minimum 5. You have to pull out judges from different jurisdictions who are doing matters in division benches or 3 judges combination to constitute those constitution benches. So it's a difficult task for a Chief Justice. And you've seen recently there have been 5 judges benches, 7 judges benches, 9 judges benches. That means that at least 7 courts are disturbed or 5 courts are disturbed to get them all on board. It's a difficult task. So that's why constitution benches take much longer for them to reach hearings or for them to be finalized. But there has been a lot of improvement in that area, you will notice, in the past couple of years. There have been several constitution benches where matters that were pending have been taken up. Perhaps they should have been taken up earlier, but the 3 years of COVID have also given a major setback to the predecessor Chief Justices who couldn't go that way. So things were moving and have been moving pretty fast so that most of the constitution benches, as many as possible, can be disposed of. So it's a struggle for anybody as a Chief Justice on the administrative side to constitute those benches, because judges come back many times and say, look, I'm in the midst of such an important matter, maybe a death reference, something equally important, maybe something to do with life and liberty. If I'm pulled out, then all that goes for a 6. So those are also practical issues that behind the scene on the administrative side that a Chief Justice has to deal with.
But on the government's refrain, you've heard this in so many of your cases as well. Where they would say, let's say, national security, or nowadays you've even heard, this is very culturally and it has a lot of societal significance, so we need wider.
I'll give you a random example, which need not be on the NIA aspect. But for example, that matter of which we ordinarily is known as the Indian Medical Association matter, where there was a contempt against one of the parties. In that, when we went into that matter, and I'm not talking the contempt because that was a contempt, that is a separate issue. The aspect was to make public aware.
This is the Patanjali matter.
Right, to make the public aware of what kind of misleading advertisements were going in the market, and many of us wouldn't read the fine print. So then one did exercise, that bench of which I was heading, we exercised Article 142 to stay the hands of all advertisers to go straight without, whether social media or otherwise, internet, without having a filtering process, so that they would make declarations and then only they would come back. Now that was something we did by exercising our powers under 142, because we found that it was a green field. There was nothing in the statute specifically which dealt with this aspect. And immediately we had a series of petitions, applications coming from interveners, which included those who were advertisers themselves and others, as also the government, to say, look, why, this is creating a problem. We are having difficulties putting out the advertisement. This kind of declarations are all many times. By the time the declarations are given, that advertisement has lost its relevance, because advertisements also are some things that go by days and seasons and so on and so forth. And that's when the government also came back and said, look, we need to, I think it was Ministry of Health and Information and Broadcast, all of them. They said, we need to have a relook at it. There was resistance, because they felt that perhaps there was a better way of doing it. So what did we do? We said, this will continue. You quickly have a meeting, get all the stakeholders on board, not just the government agencies, but all the stakeholders who were applicants on board, come back to us and tell us, how would you go about it? We will fine tune it. So there was a resistance, no doubt. We have to deal with it then. There are ways of dealing with it. If that policy would come back to us, again the judicial review would apply.
We'll take some questions from here. Is the mic? Can someone pass it on the mic? There's no mic?
There's one here.
Ajoy.
Is it Ajoy?
This is Ajoy.
Hi, Ajoy.
He writes on law.
Hi.
Hello.
So I just want to ask you were just talking about So you're just talking about how the sort of judicial machinery gets sort of interrupted when there's a constitutional bench that needs to be created. So, and it's also no secret that the court is dealing with a bit of an unprecedented pendency crisis at this point. If not unprecedented, then it hasn't been dealt with a crisis like this in almost 70 years. With that in mind, is there an effect that these constitutional benches have on like the overall pendency at the court? And is there, and this is a question I actually asked to Mr. Saurabh Kirpal, who came a couple of weeks ago, is there an argument that this court should be more discerning about what cases it chooses to hear, what cases it chooses to accept at some level? Because it seems like almost everything is making its way there at some point. So,
yes, Ajoy, there are two aspects to the matter. One is that those constitution benches that were to probably didn't assemble for a long time. I would attribute a large part to the COVID phase. Many of the courts took a real impact, serious impact on pendency, and I'm not talking of only the Supreme Court, pan-India. What was perhaps 70,000 pendency doubled due to the impact of the COVID and the fact that the courts were doing selective matters and they couldn't do more than that. That was one. Two, constitution benches can't be pushed beyond a point for the reason that those issues which are constitutional issues, once those questions are framed, many times other matters which are pending before several high courts and the Supreme Court as well have to be deferred to await the outcome of the constitution bench's answers to questions posed. And they answer questions, right? Those benches don't work at random. The questions are formulated and placed before the bench. And in the course of the arguments, perhaps the parties feel that there is another question which is linked that is also framed for being answered. So the legal issues, till they are clear, all other matters are on hold. So there has to be a balance. No doubt, constitution bench matters, many of them take a lot of time because you have to take in the views of several parties, stakeholders and all of them before you answer a question. In that process, it takes days. Sometimes they wrap up early too, depending on what are the nuances of the legal issue. But there has to be a balance in both, to my mind. As far as taking in too many matters in the Supreme Court is concerned, compared to other countries where Supreme Courts function, they don't open the door that wide. Largely engage themselves in constitutional matters, not the kind of many of the run-of-the-mill matters that come to us right up to the Supreme Court, which includes maybe ordinary bails which have been rejected or anticipatory bails and such like, which should find perhaps a quietus at the High Court level. Maybe we open the doors wider sometimes is that to ensure that the last man in the queue has that satisfaction, and we think that he deserves the satisfaction of the order being tested, which has been passed by the court below, which could be the High Court or the District Court. We have a huge population. We know what is the ratio of the judge versus population in our country, something like what? I think 20 judges to 10 lakh population, vis-a-vis any other country which you could compare ourselves with. So there is that issue also. The number, sometimes the pendency increases also for the same reason that the number of judges suddenly go down. You know that when 9 of us took oaths together in August of 21, you could imagine how the Supreme Court must be tottering. That out of 34, there were 9 vacancies, and how would a Chief Justice handle all those matters? And that also was during COVID time. All that happened at that time. All of that got accumulated too. So these were considerations of maybe opening the door wider sometimes, which one has to be circumspect. I certainly think at an admission stage is a very important stage when you perhaps need to filter and throughout that it doesn't deserve an entry into the mainstream. Once it is mainstream, then the after notice miscellaneous list really expands. And those after notice also means a little elaborate arguments. After the very fact that notice has been issued and the matter is after notice means that your predecessor bench or maybe your own bench thought there was something that needed to be examined in that matter. And that's why it entered the stream. But when after notice is also a stage when you need to filter. So there should be one filter at admission, another at after notice. And as far as handling pendency is concerned, Various strategies are worked out by Chief Justices from time to time. You will notice that earlier, as legal reporters and correspondents, you would know that earlier transfer petitions were going, that what we call standard 24, were going to a single judge, what we call judge-at-table. Now those matters are straight coming to the division benches, which is how we sit in the Supreme Court, instead of a single judge, for the simple reason that we wanted to save time. That, the matter will mature at the registrar's level, come to the single judge, and then the single judge will decide. We said, okay, wrap it up. Let's just bring it directly to the division bench and be done with it. That was also happening. So these are some efforts were made to fine tune, to pick up dead wood, to go in for old matters, dive deeper, pick up MACTs. It was also a strategy adopted by the Chief Justice at one stage to have such judges handle particular jurisdictions who had experience on it. Take, for example, land matters, revenue matters relating to taxation, matters relating to motor accidents. Those were matters that could move faster but were getting clogged and getting delayed. So a lot of disposals happened when those special benches were constituted.
Vandita.
Ma'am, a recent video and photographs of the CJI and the Prime Minister staying together caused a lot of controversy in the bar as well as outside it.
Right.
And there are broadly two concerns. One is on the extent of the presence of religion in the public domain or the degree of it. And the second is of separation of powers. Should the Prime Minister and the CJI be seen to be playing together? So how would you look at this?
Okay, so I've taken this question and answered it earlier also, and I stand by what I said. Speaking for myself, I've always drawn that distinction because I feel that some things are very private and personal and should remain in the private domain. And other things which engage a judge should come in public domain and remain there. So if I have never gone that way of maybe interacting on the in a public space with or a private space on anything to do with religion per se. And let's draw the distinction between religion and spirituality, because that is a different domain, and spirituality has an entirely different aspect. The nuances are different. And religion would have a different nuance, more personal. So anything personal, and not just religion. To my mind, anything which is very personal and private, I would not like to come out with it in a public domain. I'd rather keep it to myself, because that is I think as a judge, I need to draw the line and keep that, because end of the day, what am I looking at? Who's the ultimate consumer of justice? A litigant. And a litigant could be coming from various backgrounds. He or she is not concerned with what my private life is all about. He's concerned with how I deal with a matter and how I decide a matter. So the impression shouldn't go for any reason that my view was colored in any manner.
What about the second concern, the separation of powers?
So separation of powers, I've always said that there is and has been a friction. I wouldn't call it go to the extent of saying there's a fight. There are no war zones here. There is a friction. It's like, and it's required, it's healthy. If there is a separation of powers, it's meant to keep insulated the three wings, and particularly the judiciary, so that it remains in balance. There should be what you would call perhaps steel wood between two boards, so that insulation. But when it comes to aspects relating to the administration of justice, I'm not talking of dispensation of justice. Administration of justice requires human manpower, it requires infrastructure, it requires things for which the judiciary has to look at the executive and the legislature. The interface between these wings at that time is imperative. It happens in routine. It should happen. Otherwise, how would we get the kind of funds and budgeting that is required? Besides the consolidated funds, because where will we get land? We'll get land only when we go to the government and say, look, we want to set up courts. These are districts which don't have courts, or these are districts which have a lot of population, we need more courts, or we need more manpower, we need more posts created. All that goes through that wing. So if we don't have an interface, it'll be a deadlock. That can't be expected. That shouldn't happen. It's in the interest of the litigant that interface continues.
Ma'am, I'm not sure if it is in your jurisdiction or not.
First, I need to know your name.
I'm Praveen Dogra.
Hi, Praveen.
Every time we see when Gurmeet Ram Rahim comes out of jail on furloughs, on paroles, and he comes out just before ahead of elections. So, as a Supreme Court judge, as one of the top judges in India, how do you see this personally? And can Supreme Court take suo motu cognizance of such incidents where we see, it becomes mockery of our judicial system because it is being discussed around, the state which goes into election just tomorrow or the day after.
So there's a contradiction in your question because you said as a Supreme Court judge, how do I see it personally? Either I see it as a Supreme Court judge or I see it personally. That's one. Sorry for dissecting it, but that's how we are honed to do it. So there are two questions. As a Supreme Court judge, well, I've laid down office. If such a situation would have perhaps come up before me, and now we are talking of hypothetically, maybe this would have weighed with the court that what is the time for, what is the crucial time and critical time when this has happened. Let's not forget, furlough is the prerogative of the state. It's not to do with the court. The courts don't give furlough. It is the executive that has carved out a criteria for giving furlough. And paroles, they're not orders that come to the court. It's only when that's refused to parties who are aggrieved come to court saying we've not got parole, though others have got it, or our furlough periods have been shorter than others, or the party concerned, convict, or the person behind bars says, I applied but my application is pending. That is the role of the court. Furlough is purely the domain of the executive. So if they have faltered, it is for somebody to point it out to the court. Courts are not party to it. Those are not orders of the court. If it is happening and it is noticed, then some public spirited person, if he or she brings it to the notice of the court and questions it, well, there are orders that you're aware of where the courts have upturned such orders of parole or furlough, noticing that it has happened too often, or it has happened too strategically, or there is no justification for giving that many furloughs or paroles. So that's when the court comes in. At the stage of granting it, it is a body. It is a committee that looks into the background of a particular convict and a criteria on the basis of which they pass such an order. So it's an administrative order, really speaking. It's not a judicial order.
But I think his larger point that, this entire exercise does look like the judicial process is, there's a mockery of that. And
so what if somebody, he's giving a live example, any example, what if somebody went to court and challenged it? It's not the first time it would have been challenged. We are aware of it happening very recently and there were consequences that followed. So it's not as if the courts have not intervened. They have. That's what I mean to say. Hi, Akash.
I have two unrelated questions. The first one, when you talked about that the perception of impartiality is almost paramount for a judge. In a lot of cases for lay people, we see the post-retirement appointments, often political appointments, and then one cannot but help read back or speculate on motives then at the time of politically sensitive matters when the judgments were made. As a cooling off period has been suggested, there's been some. What do you make of that? Just in the interest of the judiciary's doing.
So Akash, I would say you can't taint an entire body of work done by a judge, which is a time span which can run up to from 10 years to 20 plus years, on a presumption that at the end of that tenure, something was offered to him, so she or he works backwards and starts from the starting point to give a particular slant to the judgment. I'm not willing to accept it. It can't be. If you're talking of the last phase, perhaps, then again it is a call of that particular judge, and to accept an assignment or not. But to say that would there be a slant on all that he or she has decided over a span of a couple of decades would be really carrying it a bit far, to my mind.
So let's say even but what is that? I think just the perception of it, because it's like appraisal ke pehle hum log every year you sort of get extra excited and you want to show.
the image, I'm not whether the truth to that perception is something that is a dangerous one especially for the higher judiciary, for the constitutional court, because they're dealing with very, what do you make
Sensitive
of that
matters.
Sensitive.
And can I also, is there a particular kind of an assignment? You know, being a head of a tribunal is one thing, being an arbitrator in another case is one thing, being a Rajya Sabha member is entirely different, or being a governor is even different.
So there are demarcations. There are demarcations in that, as Apurva rightly has pointed out. So maybe the latter two, speaking for myself, I would never look at. I wouldn't look at it if it was something that was offered. I wouldn't go that way. I'd be clear in my mind that this perhaps doesn't fit the bill. And again, maybe it was something like a tribunal, an NGT, DRAT or a DRT, depending on who the judges. DRATs are normally for the High Court judges and so on and so forth. Those kind of assignments had to do with judicial work, which is pretty par for the course.
One unrelated question is, how has the court changed and what do you make of the live telecast? Because we've all been watching now the Supreme Court in a way that we never did.
You're so right. I think it's the perfect thing to do in today's day and time. We are living in the world of AI, and that has entered our homes, our hearts, our courts, everywhere. So how can we insulate ourselves completely from being put on the domain for public to see how courts function? It works, and to my mind, it's better. Public doesn't know how courts function. If they actually log in, they see how courts function. It gives them an idea what weighs with the court. They are confident that there's a lawyer who's actually appearing. What used to happen earlier was the litigant would bank on the lawyer and give the power of attorney, and many of them wouldn't ever come to court themselves. There were reasons for that. Every high court is not like the NCT of Delhi, where you just come from Rohini or Dwarka, enter the court premises. Sharjah Road is not far away, Shersha Road is not far away. But when you're talking of districts like Madhya Pradesh, like UP, who in the far rural areas, because he has a case, would like to come to Lucknow or Allahabad to see how the matter is. Now, with courts being beamed live, all the person has to do is to log in to see what's happening. It gives her an idea or gives him an idea which way the matter is going. So anything that the lawyer may say is tested by the client also to check how it's going. And I think the more the sunlight, the better for all of us. There's no harm in it at all.
Are there any downsides?
Downsides are also there. And I think for that, perhaps the media needs to introspect. Out of context statements quoted can create some kind of impressions, misimpressions. As judges, we ask a lot of questions. It is our duty to do so wherever we feel that we need clarifications, because if we won't do so and go with the presumption, which has not been clarified by a counsel, it could impact the case adversely. So, when we ask questions, there's nothing in the mind but seeking clarity. Many times just knowing which way the counsel is building her case or his case. If that is quoted out of context, it unnecessarily gives a slant to the matter which may not be in the mind of the judge at all at that time.
But when that happens, I want to ask you, especially with this Patanjali case that
Yes.
you're hearing, and do you think of public perception at all, or how does it come into your mind?
Speaking for myself, and if you're talking of this case in particular, because perhaps it was high profile and a contempt, we handle contempts all the time, don't we? And
No, but this case also you saw packed courtrooms.
that's just curiosity for
Yeah.
public related to that person. He's somebody who's a personality.
Yeah.
Who has the whole yoga world, and I would say national, internationally, was known. So obviously there was curiosity. Can't blame people for being
Yeah.
curious. Yes, it was a packed court, but end of the day, you have to deal with the matter and the issue at hand. So really speaking for myself, I didn't think that I didn't come under any pressure. Ultimately, it's for me to take a call whether I come under pressure or not. I can't come under pressure if I don't want to come under pressure. That's how it works.
The other thing I wanted to ask you is, you've been part of the Supreme Court Gender Sensitization Committee and
Yes.
these things.
Yes.
I know this was at a time when you were not in the Supreme Court. But now, with the benefit of hindsight, how do you see the sexual harassment issue play out when Justice Gogoi was the Chief Justice? Because now that it's been a few years, you can sort of look back and see what was the court's role, and could there have been a different response?
See, I'll answer it differently. I was also heading the we call it Gender Sensitization Committee in the Supreme Court. It is called the internal committees in the High Court. Earlier they were known as internal complaints committees, now called as internal committees. I was heading the one in the Delhi High Court too, perchance. At that time, and these matters, a lot of matters come to us, many times between employees of the court itself, many times relating to a judicial officer vis-a-vis a lawyer or a staff member. The domain of the internal committee of a court is limited, it does not extend to any complaint from an advocate vis-a-vis the aggressor advocate. No, it goes to the bar council. Half of the time people don't even know that. They think every complaint is coming to the sensitization committee. That's not the case. There are committees constituted by the bar council also. They're required to state bar councils, ultimately the Bar Council of India, because appeals go to the Bar Council of India's committee. When it comes to those kind of complaints which are between staff members or between a judicial officer and an advocate or a staff member, they come to us. In the High Court, we had one example. The matter's over, so I can, I don't need to take names. Was one where there was a complaint by a court staff lady against the judge, presiding judge, under whom she was working. And it landed up at our door. And that once that complaint comes first, there is a preliminary hearing, and we get to know the details by calling both sides for their versions. If we think that the matter needs to be taken further, then only we give a report to the full court, and the full court then decides that looking at it, and when it's a judicial officer, then doubly so, because there are norms for disciplinary action. And the sensitization committee then acquires the role of being the disciplinary body, but ultimately the call is of the full court, which way they want to go on the recommendation of the committee. In that case, we meaning 5 of us, which comprised of me, my 2 colleagues at that time, a representative from the registry and an independent representative who was a lawyer. We took 4 months to have the entire affidavit examination, cross-examination, everything done with screens and with lawyers from both sides, though lawyers are ordinarily not permitted, because we felt that the lady wanted a lawyer and we didn't see any reason why we would deny the aggressor the same right. We had to balance equities, rule of law applies in all of this. We did that exercise and came to the conclusion that it was a fit case where a major penalty should be imposed, which was imposed by the full court on taking a call. And that major penalty, when it was tested in the Supreme Court, was upheld. So that process was followed and taken to its logical conclusion. So there are cases and cases. It is for you at that point in time who's in charge and what is happening to take a call. Of course, it didn't happen in this, but in the Supreme Court, the Gender Sensitization Committee was not accosted by anything like that. But I'm giving you a living example of how we handle it and brought it to a closure.
No, I'm just talking about it when you zoom out, what happens to the perception also, because that plays a big role. This is the Chief Justice of India and not, any staffer or a registrar in the court. So does it dent the image of the judiciary because of how you handle it? And that's a big responsibility as well.
Perhaps the very fact that you're answering this question gives an impression that there has been a dent. Otherwise, maybe you wouldn't be asking this question. Inherent in your question seems to be the answer.
Good afternoon, ma'am. I'm Vedant.
Hi, Vedant.
Basically, as you lead the Supreme Court, how do you look at the state of the judiciary today? You have seen it over a period of time. Can we really take the freedoms or the independence of the judiciary for granted? What are the challenges ahead?
So that's a very open-ended question. How have we proceeded so far? I think 75 years has done us good. We have evolved. It's not just a constitution of India that is we talk of organic growth and evolution. It's not a dead document, it's considered a living document. When it's a living document, then there are judges who put life in that document. They interpret it in manners to bring it to the next level, to read into it rights that perhaps were not contemplated by the constitution makers. So had it not evolved, perhaps there were many judgments that would still be holding good, which have been watered down, which have been quashed and set aside, our own judgments, having revisited those issues at a later date and time. So there can't be any question. I think there shouldn't be any question of the evolution or the growth of the institution. The institution is growing, is willing to learn at its own experience and grow further. Perhaps the anxiety is that does it continue to remain as insulated as it should from any pulls and pressures? So it would again depend on what kind of judges man those courts. And I'm not using the gender term of manning by saying how many judges woman the court. Well, they do. Many of us carry our perspectives and our experience when we come on board, and interpret statutes in a manner which will take it to the next level. And that is the growth. I think that as long as that growth is going on well, there is a chart that shows that upward movement. We are on par, but again, one should not be complacent. There is no space for complacency. Just as our democracy is growing, our population is growing, our statutes are multiplying, we also have to keep pace with that. And that is the challenge, inherent challenge of keeping pace with it and bringing it to the next level and making it more broader, more space for more litigants to get more reliefs, to be able to deal with, as you said, pendency is a big issue with people keep highlighting, and rightly so. I'm not questioning it. Somebody whose life is at stake, whose career is at stake, whose money is at stake, would certainly like the matter to be brought to a closure. The effort is there, but then it has to be, we have to not forget the ground realities of how many judges vis-a-vis how many cases. That is something we must also keep in mind when we talk of that.
So specifically, if I would like, if you could elaborate on the fact that you talked about, the institution being insulated from the pulls and pressures. So are there enough safeguards, or these need to be reviewed, these needs to be looked at further? Is there an evolution on that?
Shall I say there should be more, if it is required, there should be introspection. We're not talking of external safeguards. We're talking of introspection. It should come from within. It should, it has to. If it doesn't, then they can't, how many barriers will you create? Those should be self-built, and those should remain as, and one looks at how one's senior colleagues would conduct themselves, one learned from them, and that is why it's very important to hone those skills hands-on. That is why single judges, when they become judges in the High Court and constitutional courts, invariably sit in division benches, because they see how their colleague is functioning. How are you to handle the court? How are you to handle litigants? How are you to handle a matter? What is your conduct what ought to be your conduct as a judge when you sit on that dais? You're not being that human being, you keep yourself away from and draw that line. Those are learning experiences that you grow up with in the judiciary. Then you go to the next level. Then you yourself start heading benches. One starts by being a puny judge, single judge, after sitting in a division bench, keeping in mind that what you've learned is how you will work around it. After all, lawyers haven't been writing judgments when they come to the bench. They also learn it hands-on. They've been drafting, but drafting judgments is very different from drafting petitions, replies and counters and all that. So it's an ever-evolving learning experience. So insulation also happens when you see what's happening around you. You learn how to build some walls to isolate yourself, but I always do think that isolation shouldn't be meaning that you live in an ivory tower. Your hand should be on the pulse of the society. In today's day and time, as judges, one can't be cut out from reality. That would not be good for the system. One should know how the public is dealing with issues, what are the difficulties they are facing, and how best can we ameliorate them.
And one last thing, that on institutional memory of the Supreme Court,
Yes.
because they've got stellar chief justices, they've got justices over a period of time who have left a mark based on their judgments. But there is so much more which happens in the courtroom and inside the courtroom or within the judge fraternity that probably is not really institutionalized memory. So how do you kind of institutionalize such memory so that future judges or next 200 years of judges get to know how did judges react to such?
On the personal front,
No, even in
relating to
public-
matters.
yeah,
Are you
relating
talking
to
public domain?
Yeah, no, which is not in public domain.
So some things need not be in public domain to my mind. Say if you had to sit and mull over how many of us worked around constitution bench judgments, those are not things that should come in public domain or should be chronicled. Those are things that should be left because we need a lot of play in the joints for that. Let's not forget, most of the judges in these courts, and I'm specifically talking of the Supreme Court and not the High Courts, because invariably in High Courts you come from the same background, same state, same bar, you have interfaced with each other at different levels before one ends up going on the bench. But in the Supreme Court, one is coming from different states, different backgrounds, different cultural routines, and so many other things, educational backgrounds, leanings, personal preferences. So to sit together and thrash out issues many times is required, because you don't even know which way your colleague sitting with you would go. We don't sit on the dais and start asking each other, now what brother, what do you want to, what do you think? Many times when we reserve it, we think about it, we meet each other and we talk about things. But those are very personal and private, to the point that if a matter is going on in a particular court, I wouldn't ask my sister or brother judge, oh, which way are you going? Not at all. It's like taboo. I wouldn't expect anybody else to ask me, which includes the Chief Justice of India, because he's one amongst equal when he or she is sitting in court. So I think some things need to be chronicled and others don't need to. This is a word of mouth experience, just as we say grandma's stories.
Yeah.
Those are experiences which we learn from our seniors, colleagues, who we meet outside of court later on, and when we exchange notes. And those are unspoken rules that you don't chronicle it.
But this taking off from this is also important because you've seen so many conversations around how to be a judge or how to learn to be a judge in the last couple of years.
Absolutely.
Whether that's say, for example, the Calcutta High Court judge who resigned and joined BJP, Abhijit Gangotpaধ্yaय, or the Karnataka High Court sitting judge who made this, some areas a Pakistan comment. There've been so many in the last few years. So how does one get that training of so many attributes that you mentioned, impartiality, not taking into pressure.
Yes.
So how do you learn that?
So there are two fora for that, and those are things which are in public domain, which everybody knows. The academies, the judicial academies. We have judicial academies at state level. We have a judicial academies, which is a national judicial academy for. So state level judicial academies ordinarily are places where we train our young judges who come into the judiciary, the district judiciary. Those are hands-on trainings. They are academics and they are practical things that those judges are supposed to be taught, because they're also coming from the bar, or they're also coming as somebody as students. Many of the young magistrates are straight coming from law schools into, and you will appreciate that the powers of a magistrate are huge if they're used. At that level, that's the first interface of a litigant with a court, the magistrate's court. So they have to be trained to do all of that work and learn how to balance themselves. That is the place, institution, where many of us judges would go to train them, besides the academic aspect, the hands-on. Another aspect of the training would be to come and sit in court and watch the judges, senior judges, function and perform. They would actually sit where the court master sits and observe, take and rotate. They will not sit in one court. They'll be rotated to different courts. So they learn, X judge handles it like that, this one handles it like that. Perhaps I can take the middle path. This is how I'd like to go when I sit. And many of them come back and tell us that it was good, worth it. We picked up things, we came back with something, we went back richer. When it happens to a lawyer who's invited to the bench, then the lawyer has not gone through the process again. That's where judicial academies play a role. The National Judicial Academy at Bhopal is the learning ground, where the senior judges are invited to interact with them, to sit with them, to explain to them how to conduct themselves in court, how to behave. What are the norms? Of course, we have the Bangalore Declaration of, which was now several years ago, a couple of decades ago. But then times have also changed. Those things are taught hands-on in those academies to the judges. And as I said, when you come in as a new judge, invariably you sit with the senior judge. And that senior judge is normally the first five amongst, depending on the number of judges who come in a pool, who sit with the first five to learn how to go about it. It happens in Supreme Court. Most of us who came in, and that's a living example, 9 of us, we all sat with the 1, 2, 3, 4, 5 down the line and saw how those judges were working, because the manner of functioning of each court is different. What is good for the High Court doesn't work for the Supreme Court. There are different manners of handling matters, There are different the bar is different. I was lucky because probably there's a familiar bar. I belong to Delhi. That's not necessary for the other judges and colleagues. So that's how we hone our skills.
Yeah. Hi, Nikhil.
Hi, Nikhil.
Ma'am, last weekend you were addressing law students at Travancore House. I was there, and you made an interesting
Yes.
point regarding the evolving jurisprudence on climate change.
Right.
You made a very interesting point that it's very difficult for the courts also to establish and basically the attributing factors behind certain issues, and how will this evolve in the years ahead, especially when the cases now increase with the swell in terms of fixing accountability for
Climate damage.
climate damages. And a subset, section of this question is that regarding the judgment on the Bustard issue. Now the government took an approach that we have to meet our goals
Yes.
committed in the international fora. But given the kind of transboundary impacts happening and also the impacts happening because of our own actions,
Right.
how far can the government keep on justifying on the basis of our commitments while at the cost of biodiversity getting affected?
See, one.
Can I ask a related question?
That's a related question, maybe you can take both together.
Please.
My name is Kaushik.
I got you.
In March, I think, the Supreme Court had said that right to be protected against climate changes,
Adverse impacts.
adverse impacts of climate change is part of the right to life. Now, unlike clean air or clean water, where we can establish direct connections, climate change is something that one cannot establish the direct connections between X event and
The
maybe,
consequence.
So, how do you see the courts looking at litigations
Related to.
related to
See, the first forum, I think, mostly abroad, you'll agree that they have a completely different jurisdiction, which is only jurisdiction related to environments, and those environment matters don't come to regular courts. That is happening at the NGT level, we all know, but then Supreme Court has the power to examine what NGT is doing and take it further. Some of the areas are earmarked for the high courts to do. So it's not that it is completely out of the jurisdiction of state high courts under 226. That's one part. No doubt that climate change impact is a little convoluted because you have to then link the whole chain to be able to draw the conclusion that this particular incident related in this impact, which is how an individual has been affected. There has to be expert opinions. One will have to, at any stage, in any of these pollution related and climate matters, you know that we don't take a call ourselves. We first ask an expert body's view. We ask for those within the government to give their own report. We ask for outsiders to give a report to give us a larger picture. And then are a little careful in passing orders, which are not sweeping, but they one step at a time. And that is why the forest matter went on and on for such a long time, with series of orders coming in, depending on what came up before the court, and became more broad-based from what it started. That time we were looking at climate protection largely. Today we are looking at the adverse effect of the climate change on the population, and that's why it's being interpreted to be a part of a facet of the right to life. It's going to be difficult because when we talk of damages and all of that, it's not easy to assess. In European countries and their fora, recently the Swiss government, as you know, was held responsible for not doing enough. It was not that what they were doing, but perhaps what they were not doing, which caused a damage, and they had to quantify the damages. We have yet to reach that stage. Yes, one of the biggest challenges is our population and the constant eating into the green lungs of every state or city, which has a serious impact on the entire population. So some of the population itself needs to be addressed to keep that balance. Two, ours is, we have a developed country now, we've reached that stage, but the economic development has to go hand in hand. We have to keep in mind the economic sustainability vis-a-vis the environment sustainability. we can't completely overlook that aspect because development is equally important for our country. So keeping that balance is also a challenge which the judiciary has to handle. How far can one go and where should one draw the line? When that happens, that's why these what we call continuing mandamus, the writ of continuing mandamus, one passes orders. When somebody comes back and says, look, this is how it's impacted, you know that initially in many forest areas, boundaries were drawn on what is the extent, the diameters were drawn, circumferences were drawn, that up to this point you can enter, beyond that you can't. They were from time to time tweaked, made more narrow at some places and broader in other places. So it's an ongoing process. It's not going to happen overnight, but I think we are charting the right course. We are now in a position as a country to say that the Indian courts are examining the impact of climate change and the damage caused to the citizen, which was an aspect which was not engaging us till recently. So it's a big step forward to my mind. That judgment itself is a big step forward, the Bustard judgment. Rather Raj Singh judgment, right?
Ranjit Singh.
Ranjit Singh judgment.
I think there's a queue for us there, but we'll take one last question and then we'll.
And I thought we were looking at the food. Yes.
Damini, my question is regarding assets of judges.
Yes, Damini.
Should
No, I can hear you. Relax. So can the rest. It's okay.
recording?
Oh, I'm sorry. If it's for recording, then you need to.
Right.
Is it working? Yes, Damini.
So, ma'am, should judges' assets be declared and should it be in the public domain? Do you think the public has a right to know, the assets of judges?
So just to tell you, the assets are declared. When we,
No, ma'am, in the public domain, should it be?
I don't. I think it's more important that it is declared and kept in a sealed cover with the Chief Justice, which is a procedure. And whenever it's required, it's updated also. The returns are filed when there is a change in the status in any manner. The idea is for the institution to know that when you entered the institution, what was one's assets, movable and immovable, and if there has been a change, to inform them. When it comes to the district judiciary, they file an annual return where they declare their assets. They're also called upon to state and take permissions for some things like taking a big loan, lending amounts to somebody, or borrowing money from a banker or an FI. That's there. In the high courts and the Supreme Court, we declare our assets, put it in a sealed cover and give it to the Chief Justice. Sometimes there are issues relating, which we found, sometimes judges did ask for redaction of some assets. Our assets are in public domain, by the way. Those declarations are in public domain. And if you go on the net, you will find them all there. They are not just sealed in line with the Chief Justice. But when it comes to maybe a spouse or a child, the dependents of the judge, many times or sometimes some judges want a redaction because they want to protect any infringement in the privacy of the spouse who may be working independently and has his or her own sources of income, and or a child for security reasons. Those redactions are left in a sealed cover with the Chief Justice. But our assets are all in public domain.
Ma'am, the two questions in one.
Yes.
But now, when you left office just a month ago, are there things that take up your mind, worry you about the institution? And one of those areas of concern, if I might tell you, I think this was 2015 when you had the NJAC, that was government's giving the government a foot in the door and appointments. Now, let's say 10 years later, is there, do you see another NJAC, or is the NJAC idea of NJAC dead? Is that an area of concern as well?
When you talk of demitting office or laying down office and coming out of a system, on my last day when I gave my farewell speech, I had said, work when you are in a system and work as hard. When you're done, be done. I think that should answer it, because I feel that I'm done. And I don't see why, on hindsight, I will engage myself in this debate, because it is when you're in the institution, it is for you to be part of it, to say what you have to give your views, because they count. when you're out of an institution, I would say that I've stepped back. Now it's time for me to don another role. I don't need to look back on some things. I don't feel like, let's not say I don't need to, maybe others too in my position. I don't think I should look back on hindsight and say, this should have been done and not done. Whatever I had to say, whenever I got an opportunity, I said it when it mattered, when I was in the system.
Yeah, but maybe for our benefit.
I don't think I need to benefit you for that.
Should the government have a role or sort of have a seat at the table in deciding who the judges should be?
So, the government already has a role when IB reports are called for. How do we assume the government doesn't have a role? The moment a name goes and this comes in the zone of consideration, the names go for an IB clearance. What is an IB clearance? The input that the government gives about a candidate. Those inputs come to the collegium and the collegium goes through those inputs. If it has questions to ask on those IB reports, there are further interactions with the government. IB is only part of that, to ask about a candidate or to inquire. If they think that the reports are fine, they go ahead with it. So that interface is always there. So how can we say that they should have a role? They have a role. We must make it clear that that interface is the role they have. After all, files come back from the government to the collegium many times with their own queries, which are answered by the collegium. Or they go back from the collegium to the government with more queries about some particular individual whose IB report may not be good, or there may be question marks, or may be ambiguous. So the role is there. One must recognize that they have a role and they are playing a role.
But they should not have a veto.
Yes, they shouldn't have a veto because within the system, the collegium has an input from several sources. Many of us, and again I'm saying now that I'm done, but I'm only sharing with you the fact that there is something like a consultation by the judges beyond the collegium, which the public perhaps is not aware of. What we call the role of a consultee judge. A consultee judge is a judge who comes from that state, from where the name has come to the collegium. That judge will also give his or her input about the candidate. It's after taking a well-rounded view of all of that the collegium takes a call. So they've got inputs from various sources. And then they take a call on that particular candidate.
Thank you so much.
Now I think I've earned my lunch. I'm so happy.
That's a very hopeful note.
Thank you so much.